you can be a part of today's podcast. So, this podcast is every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And currently 6 p.m. Nigerian Time. So, you are welcome. If you are joining us for the first time, we do this every week. Remember to subscribe so that whenever we go live, you can be notified. So today we are discussing Adam Walsh Act, and it's a very, very, very important topic. Adam Walsh Act. A lot of people don't understand the way immigration works. Immigration law in the United States is extremely complicated. Even some general lawyers who are not experts in immigration matters, they may not be familiar with the consequence of Adam Walsh Act. We have seen this from experience. That is why we are addressing it. We are addressing Adam Walsh Act because of the significance it does have on immigration benefit. What is Adam Walsh Act? Adam Walsh Act is a law that was enacted by the United States Congress in 2006 and signed into law by President George Bush Jr. It was meant to protect children in the United States. It was actually named after a victim, Adam Walsh, who was a victim of kidnapping at the time. He was kidnapped and subsequently his body was found. He was killed. So the father put a lot of political pressure on the Congress. And of course, at the end of the day, the Congress decided to pass a law to protect children. Now, you may be wondering, how is this relevant to immigration? That is exactly the point we want to address today. When Adam Walsh Act was passed into law, the effect on immigration is that U.S. citizens, I'm not even talking of permanent residents right now, because permanent residents who are convicted of Adam Walsh Act will definitely be deported. But I'm talking of U.S. citizens. U.S. citizens who are convicted of a crime under Adam Walsh Act, they may not be able to petition for anybody in the United States. They may not be able to petition for spouses. So, where U.S. citizens are convicted of Adam Walsh Act, if such a convicted citizen decided to marry a foreigner, unfortunately, they will not be able to petition for the foreigner. We are addressing this today because we see how it impacts families. We see how a lot of people entered into a marriage legitimately, even marriages with children, without realizing that the U.S. citizen petitioner was actually involved or convicted of Adam Walsh Act, thereby preventing the U.S. citizen from being able to file a petition on behalf of the beneficiary. You can see how significant the impact will be on the spouse. If you marry somebody today, believing that you have found your bone of bone and your life partner, you got married, have children, now this person filed a petition on your behalf only to discover that the petition is not approvable, that would be devastating. And we see this from time to time. In fact, some years back, over 10 years now, I encountered a client who went into a very, very elaborate wedding ceremony with somebody who innocently did not realize that he cannot file a petition on behalf of this new bride. So after the marriage, the petition was submitted, and of course, immigration denied it. And the petitioner, who is a US citizen, who was born in this country, did not understand why he cannot petition for his wife. But we have to explain to him what Adam Walsh Act means. Now, is Adam Walsh Act the final law? Is there any form of exceptions to it? Yes, there are very, very limited exceptions. And these limited exceptions, they are not even reviewable by any court. They are not subject to any appeal. So they are 100% discretionary at the discretion of the officer who is adjudicating the case. But we will go into that when we go into the details of Adam Walsh Act. But right now, I'm just explaining what Adam Walsh Act is. Now, the next thing I want to discuss, what offenses constitute Adam Walsh Act? We know that on this podcast, we have discussed so many topics that relate to offenses. And every time, I always want to make it clear the different offenses and the different impact, the different implications of each of these offenses. So for Adam Walsh Act, I will list the offenses and explain the danger, because some of us, we have children, especially in this Gen Z age. We have children who are doing things innocently, who just feel that they are on social media enjoying themselves, but they are creating a problem that may not be solved for themselves in the future. So that is one of the reasons we are discussing this. That is one of the reasons we are discussing this. So what offenses are involved with the Adam Walsh Act? So I've written down the list of the offenses that are covered under Adam Walsh Act. The first one, any offense involving kidnapping, unless the kidnapping is committed by a parent. Of course, you can't be accused of kidnapping your own child. For as long as that child is a minor, you cannot be accused of kidnapping your own child. So if the person being accused is the parent, that will not be an issue. The next offense, any offense involving false imprisonment, unless committed by a parent or guardian. Again, if your child is a minor, it is unlikely that you can be accused of falsely imprisoning your own child. For example, you can stay in your house and decide your child is not going to step out of the house. That cannot be classified as an offense against you because you are the parent or you are the guardian, except where some other abuses are involved. Then CPS may come in and all that. But generally, talking about false imprisonment. False imprisonment is when you prevent somebody against their own will from going out of a particular minor and is your child or somebody you are guiding. Definitely, you may not be convicted of a kidnapping offense. So that is why that exception is there. So again, the first offense, any offense involving kidnapping unless committed by a parent or guardian. Any offense involving false imprisonment unless committed by a parent or guardian. The third one, solicitation to engage in sexual conduct. Solicitation to engage in sexual conduct. You see, the topic we are discussing today affects U.S. citizens more than any other person. It affects U.S. citizens. So those who don't pay attention, you think that because you are a U.S. citizen, that is the end of the world. No. you may be trapped in these offenses. That is why we are doing this topic today. So the third offense, solicitation to engage in sexual conduct. The fourth one, the fourth offense, use in sexual performance. If you use any child for the purpose of performing sexual acts, such a person is affected by Adam Walsh Act and may not be able to file a petition on behalf of anybody under the immigration law in the United States. The next one, which is, I'm going to spend considerable time on this one. I'm just going to mention it and then come back to it after I finish listing all the offenses. I'm going to spend a lot of time on this because this is where I believe that our children, they get themselves in trouble unknowingly. And that is why it is important for parents to pay attention to all this information we are providing free of charge. That one is called video voyeurism. Video voyeurism. I'll come back to explain it. But for now, let me go to the next offense. The next offense is possession, production, or distribution of child pornography. Possession, production, or distribution of child pornography. It's an issue. It's an offense under Adam Walsh Act. So if a U.S. citizen is convicted of any of these offenses, they will not be able to file a petition on behalf of anyone, including their spouse. The next offense, criminal sexual conduct involving a minor or the use of the internet to facilitate or attempt this conduct. Criminal sexual conduct involving a minor or the use of the internet to facilitate or attempt this conduct. The last but not the least, any conduct that by its nature is a sex offense against a minor. Any conduct that by its nature is a sex offense against a minor. So generally, any offense that is sexual related against a minor. Those are the offenses under Adam Walsh Act. Now, I'm going to go back to the fifth one. That is the video voyeurism. Now, what does this mean? What this means is that if somebody is recorded secretly without their knowledge, if someone is recorded maybe by telephone or by any form, students generally, children, especially high schoolers, usually they do all these things. Maybe somebody is recorded secretly and then this recording is shared via text message among other students. For as long as the victim is not aware of it and did not consent to it, it's a problem. You see, a lot of our children share things on the internet. Even adults, a lot of people just receive certain things and just forward it. They play it on their phone and just forward it on WhatsApp, forward it on text message and all of that. All these things will be problematic, especially when it involves a minor. So if you are a child or if you are an adult and you are convicted of this offense, it is problematic. We see these things all the time, and that is why we decided to treat this topic today. So if you have been convicted of any of the offenses listed, or if you just received some form of child pornography on your phone and you just forward it to another friend or another person on WhatsApp or on text message, those come under video voyeurism, and it is a federal offense. And if somebody is convicted of it, forget about filing a petition for a spouse in the future. It is a major, major problem. I see that questions have started coming in. So I'm going to I'm going to okay. Let me just answer some of the questions that are coming in. The first question, hello sir, can you please explain what 4 years and 1 day rule mean? What does that mean? 4 years and 1 day. I don't even understand what the question is. What is 4 years and 1 day? Well, please, if you can expatiate. I don't even think the question is related to the topic we are discussing today. But if you expatiate, I probably will try to answer it later. But right now, we are discussing Adam Walsh Act, and we don't like it when people take us out of the topic of the day, because remember, this video is being recorded. Those who are not able to watch it today can always go back to rewatch it. So when we list a topic, we want to stay on that topic so that at the end of the day, when people go and check out a particular topic, it is that topic that we are discussing. So we don't go all over the place. So we limit ourselves to the topic of today, of the day. So today we are discussing Adam Walsh Act and the implication on immigration, because Adam Walsh Act is a sexual offense. It is an offense against a minor. So sexual offense does not necessarily mean rape. Or it's not limited to rape. It's not limited to. It could be anything. It could be child pornography. It could be somebody forwarding a minor content without the minor's knowledge or consent, and you forward it to somebody else over the phone or through WhatsApp or regular text. Those are offenses under Adam Walsh Act. And if anyone is convicted of an offense under Adam Walsh Act, such a person will not be able to file a petition for any spouse or anyone in the future. Now, when I was explaining this, I did mention that in limited circumstances, there could be waiver. Now, that waiver, number one, the waiver is non-reviewable. So if the waiver is applied for and is denied, there is no provision for appeal for the waiver. And the waiver is limited to the officer's decision. So if the officer, the spouse, or the officer is convinced that, okay, maybe there is evidence, there is ample evidence that this person has actually been rehabilitated, the officer is convinced that this person can no longer be a danger to the society, or especially to the spouse. So the officer, the immigration officer, in his or her discretion, may decide to waive it. But of course, it is very rare. I mean, to be honest, since I've been practicing, I've seen probably maybe 98-99% of application for waiver denied. So it is very rare. And again, because there is no room for appeal. If the waiver is denied, that's it. There is no room for appeal. There is no provision for anybody to review the decision. So it's really extremely, really limited relief. So it is better for anyone not to get himself or herself in a position where you will even need to apply for a waiver in the first place. So let me go back to the questions. So I have a question here that says, hello, sir. You mentioned that kidnapping will not apply if the child is your own child. What if I don't have custody of my child? Will that be considered an Adam Walsh Act offense? No, because the law specifically exempts parents. Of course, if you and your spouse are engaged in child custody and you decide to kidnap your own child, it cannot fall under Adam Walsh Act, because the law that created the act specifically excluded parents. So it doesn't matter whether you have custody of the child or not. If you kidnap the child and your spouse believes that you don't have custody, all he can do is to go back to court to challenge your decision, or even call the cops. If he or she has custody, he can call the cops or try to enforce the custody order, but you cannot fall under Adam Walsh Act. For as long as the child is yours, you cannot fall under Adam Walsh Act. Or even if you have legal custody of that child, even if the child is not your biological child, but if you have legal custody of the child, you cannot fall under Adam Walsh Act. So you cannot be accused of kidnapping your own child, and you cannot be accused of falsely imprisoning your own child. So Adam Walsh Act does not apply in that situation. The next question. I got my green card October 2018, travel outside the USA from November 2018 to September 2019. Since then, I've been in the USA. When can I file for citizenship? Oh, I think it's this same person. We are not going to deviate today. Today, we are discussing Adam Walsh Act. So if we have time at the end of the podcast, we'll go back to answer it. But right now, we are discussing Adam Walsh Act, and we will expect questions to be limited to Adam Walsh Act for now. The next question. Is there a waiver for those arrested or convicted under the Adam Walsh Act? Well, there's a very limited waiver, and I think I just explained it, but I will go over it again. There's a very, very limited waiver. Number one, the waiver will require that the applicant, maybe there must be, how do you classify, maybe medical providers, maybe psychologists, maybe medical providers who can certify that, okay, this person is no longer going to be a danger to the spouse or to the family members or even to the general public. But like I said, the waiver is very, very limited in nature. The USCIS officer, the immigration officer who is reviewing the case, may decide to waive it. But if that officer decides to deny it, there is no appeal. There is really nothing that you can do to challenge that decision. There is no room for appeal. There is no room for a review of that decision. But I also added that from my experience, I've been practicing immigration law now for decades. And from my experience, I have seen 99% of waiver application when it concerns Adam Walsh Act. 99% of waiver applications are denied. So it is not something, even though the law allowed it in a limited circumstances, immigration officers are very reluctant to grant the waiver because of public policy. You know the way things are in this country. If an officer decides to grant someone who is accused of who is convicted of Adam Walsh Act, if an immigration officer decides to grant a waiver, if that person committed another offense, you know that officer is going to be in trouble. People are going to criticize the officer, but you know this person has committed this offense before. Why will you waive it? Why? Especially if the offense is committed against the spouse. It will be a major, in fact, that officer may end up in jail. So that is why it is something that is rarely granted. And like I said, from my experience, 99% of the time, the waiver is denied. So it is not something that you want to count on. The best way to address this is to avoid any conviction under Adam Walsh Act. The next question. What if I completed everything I was ordered by the court to do? I now petition for my non-citizen spouse. No, it doesn't matter whether you have completed it or not. No, once you are convicted, that is it. Whether you are placed on probation and you completed your probation, it is immaterial. Whether you are sentenced and you have completed your jail term, it is immaterial. The most important thing is that, have you been convicted of Adam Walsh Act? Once the answer is yes, you cannot petition for a spouse or for anybody for that matter. You will be considered a danger for the society. So it doesn't matter the outcome. In fact, let me say this. I have a case right now on appeal that involves Adam Walsh Act. In that case, the applicant or the petitioner, the US citizen, was accused. Remember, there is a major difference between being accused and being convicted. This person was accused of an offense under Adam Walsh Act and was arrested for that purpose. But at the end of the day, he was not convicted of an Adam Walsh Act. He was convicted of a different offense, which does not fall position. And I believe very strongly that immigration is wrong, because if immigration is allowed to use arrest record for this purpose to disqualify somebody, what if somebody was arrested wrongly? What if somebody was lied against? I mean, what is the whole essence of investigation? When somebody is arrested, then the cops or the feds or the authorities, they conduct investigation. So they even if they conducted the investigation and they concluded that this person committed the offense, all they do is to charge the person to court. It is only after trial and conviction that you can now conclude that this person has actually committed this offense. So what if somebody is charged and then after trial the person is discharged? So this is a dangerous precedent in my opinion, and that is why I challenge immigration in that case. And I will update you as that case goes, because I'm willing to fight this appeal to the highest level possible, because this is a case, in my opinion, that should not come under Adam Walsh Act. Because if we allow that, then we are all going to be in trouble. It means that there is no point waiting for trial. Once you are accused of something, your life is just going to go down the drain. No, this is a democracy. This is a country of law. That is not what the law says. The law says somebody who is convicted. So for immigration to use arrest instead of conviction, in my opinion, that is clearly wrong. And of course, like I said, we have challenged it on appeal. We are going to wait for the outcome of the appeal. So the next question: will this apply to me even when I was also a minor at the time I committed the offense? Oh yes, it doesn't matter whether you are an adult or you are a minor. I mean, for as long as, you see, let me tell you the way Adam Walsh Act works. Whenever a US citizen files a petition on behalf of a family member, generally, US citizen does not provide biometrics. Biometrics or fingerprinting, as the case may be, is always provided by the beneficiary. But whenever a petition is filed, the moment immigration requests that the petitioner provide fingerprinting, that is a sign that there is an Adam Walsh Act problem right there. So whether you are a minor at the time of the offense or you are an adult at the time of the offense is immaterial. For as long as that offense shows up on your record, it's a problem. And of course, if you are now convicted of the offense, then that's it. You are bad, or your petition is going to be denied. Now, I said something when I was talking about the waiver. The limited waiver for the purpose of Adam Walsh Act, like I said, there is no provision for appeal. But the Adam Walsh Act decision itself is subject to appeal. So if your case is denied based on Adam Walsh Act, as a US citizen, you have a right of appeal. You can appeal it. So it is only the waiver that you cannot appeal. And of course, for you to even apply for a waiver, that means that you considered that you are convicted of Adam Walsh Act. Because for the way waiver work is that you are saying that, okay, yes, I was convicted of Adam Walsh Act, but that was a long time ago. Oh, I was a minor at the time. Oh, I didn't know better at the time. Now I'm a changed person. Look at my record in the last 15 years. I've not committed any offense. Look at I've consulted with a healthcare professional, and they have written recommendation confirming that I'm not a risk to my family, I'm not a risk to my spouse, I'm not a risk to the society and all of that. So I want you to waive this offense for me. So that means that you admitted that you are actually guilty of Adam Walsh Act, and you now want them to waive it. Now, that waiver does not have appeal. If they deny the waiver, there is no provision for appeal. No court or administrative agency have the authority to review that decision. But the Adam Walsh Act itself, if you file a petition and that petition is denied on the ground that you are convicted of Adam Walsh Act, but if you believe that your conviction was not an Adam Walsh Act related offense, or if you believe that immigration classification was wrong, you are not a victim, you are not someone convicted of Adam Walsh Act offense, you can appeal that decision. That one is separate. There is room for appeal. And that was what I did in the case of someone who was arrested for Adam Walsh Act offense but was convicted of a different offense which was not under Adam Walsh Act. So immigration position in that case is that once you are arrested of that offense, you remain a threat to the society. And I was telling immigration that no, you only consider the conviction, not the arrest, because the whole essence of criminal law is that an accused person is presumed innocent until proven guilty. And in this case, although this person was arrested for Adam Walsh Act offense, he was not convicted of an Adam Walsh Act offense. So that means is that he is innocent of Adam Walsh Act offense. So you cannot use an offense for which he was not convicted against him to make him permanently ineligible to petition for his or her spouse. So that is the position. So that one is appealable. So I wanted to make that very clear. The next question. Okay, I think the next question I already answered, but let me just read it. What if I was arrested for an Adam Walsh Act offense but not convicted? Yeah, I think that is what I just answered right now. But personally, I will tell you I don't have an answer for you right now, because as far as I'm concerned, immigration has denied a petition that I filed for someone who was arrested for Adam Walsh Act but was not convicted. But I filed an appeal against that decision. So until I see the outcome of the appeal, I cannot tell you authoritatively what is going to happen, as I don't know it myself. Even though I believe strongly, and I have no regret, I believe it very, very passionately that immigration is wrong. But at the end of the day, we are going to fight it in law court. So right now, we are still on appeal. So when an Adam Walsh Act offense is denied, the first step is to file an appeal at the administrative level. So that will be AAO, Administrative Appeal Office. So if the Administrative Appeal Office denies it, and of course, in this case, I can guarantee I'm going to file an appeal. So then we go to the district court. And from the district court, we go to the circuit court. And from the circuit court, if the U.S. Supreme Court decides to take the case, it will end up in U.S. Supreme Court. Otherwise, it will end up at the circuit court. But we are on that process right now, so I cannot tell you what the outcome will be. But right now, there are no precedent in that area of law The law says somebody convicted. The law didn't say somebody who is arrested. But immigration is interpreting it that if somebody is arrested for Adam Walsh Act, such a person is already a risk to the society. I disagree with them, and I will update you whenever the appeal is final. The next question: how can I find out if my spouse has been convicted of one of these offenses? Well, that's going to be problematic because you can only find out with your client's cooperation. You can only find out with your spouse cooperation. It's not something that you can find out without him or her. It's not possible, because when we are talking about Adam Walsh Act, we are not talking about police record. We are not talking of background check that you do for employment purpose. We are talking about FBI record. Immigration does not use local police department arrest record. No, that's not what immigration uses. Immigration uses FBI record. Let me tell you the difference between FBI record and every other arrest record. The difference is that for state records, when a conviction record is expunged, the state authorities will not have access to it. If your employer is conducting background check, they will not have access to it. Anybody who is conducting a background check on you, they will not have access to it once it is expunged. But I guarantee you, whether your case is expunged or not, FBI will still see it. And that is why there is a big difference. In fact, let me tell you, the example that I gave you of the case that was on appeal, I actually ran a background check myself. There was nothing on record. There was nothing. But FBI background check is completely different. They will see it. And the reason you will need your spouse cooperation is that you cannot get FBI background record without the applicant providing fingerprinting. So you are not going to be able to do it. So if you really want to know, you will need to talk to your spouse. My dear, I heard about this Adam Walsh Act. I want to be sure that we are not going to run into any problem. Will you be willing to provide FBI fingerprinting so that we conduct fingerprinting check? We conduct background check with FBI. So if your spouse is not willing to do it, then that should be a red sign. So that would be a red flag as far as I'm concerned. That's why we are providing this information, so that you don't get into it before you realize it. Because once you get into it, there's really nothing you are going to be able to do. Although in some cases, the government may be seen as trying to protect the spouse, but they may end up punishing the spouse. I mean, what happened in a situation where you marry somebody and you have been into the marriage, you have 3 children, you are living together happily, and then this issue of Adam Walsh Act came up, and the government is telling you they are trying to protect you. But if you are not able to get green card, they are not hurting the U.S. citizen. You are the one they are hurting. You are the one they are hurting, because the U.S. citizen is already a U.S. citizen. Adam Walsh Act does not take citizenship away from people. So there is really nothing that this person is losing. You are the one that is being punished, although the law's intention is actually to protect you. But unfortunately, those are some of the bad side of some of these laws. The next question. What was the last one I answered? What if I was arrested? I think I've answered that. How can I find out if I've answered that? Okay. The next question. Does immigration tell you in a denial letter if the reason for the denial is due to an Adam Walsh Act offense? Oh yes. By law, before immigration can deny a family-based petition or immigrant petition generally, by law, immigration is required. It is mandatory. It is not optional. Immigration is required to provide a notice to the petitioner. That notice is called notice of intent to deny. Notice will tell you that, okay, we discover that the petitioner in this case has been convicted of an Adam Walsh Act, and therefore he is not able to petition for this person as contained in Adam Walsh Act. Therefore, we intend to deny this petition. However, you have 30 days to respond to the petition and give us a reason why you believe we should not deny the petition. So usually they write down, they send that letter, wait 30 days, receive their response, and then go ahead to deny it. So yes, it's not something that can be done secretly. No, you can't. You will be notified. That is the law. The next question. I know that you mentioned if they take biometrics from the US citizen, it is likely an Adam Walsh Act offense. But how do they know to even request the biometrics? Well, like I said, there are limits to what we know about immigration's internal operations. But from experience, I do know that when any petition is filed, especially family petition, whenever family petition is filed, family petition requires the petitioner to show the relationship between the petitioner and the beneficiary. It is different from employment-based petition. So if I'm filing a petition for a spouse, I have to show the relationship between me and the spouse. So generally, in a family petition, immigration conducts background check on both the petitioner and the beneficiary. Remember, for those who have filed a family petition here in the US, how does immigration know that people don't live together? How do they know what the petitioner is doing versus what the beneficiary is doing? It is because they conduct background check. So there is a general background check conducted in a family-based petition. So when they conduct this family-based petition, remember, I also have to point this out. In the case of Adam Walsh Act, because it is a sexual offense, it is likely not mandatory because, again, depending on the age of the perpetrator, but where the perpetrator is an adult for this purpose means 18 years and above, that perpetrator will be listed in a sexual offense registry. Where the perpetrator is an adult, where the perpetrator is 18 years old or older, that offense, upon conviction, that perpetrator's name is listed in sexual offense registry. So when USCIS conduct initial background check, the name will show up in sexual offense registry. Then, in order to be sure that the offense is actually an Adam Walsh Act offense, immigration will now require the petitioner to submit himself or herself for biometrics, for fingerprinting. And of course, from the outcome, they can now definitively be sure that this is an Adam Walsh Act offense and subsequently deny the petition. Yes, in every family-based petition, general background checks are conducted on both the petitioner and the beneficiary. Can petition for your children or parent? Well, Adam Walsh Act general community. So that's a catch-all phrase. Even though the petition may have been for your spouse, but if immigration, by their assessment, consider that you are a danger to the community, then it will affect the petition for your parents, it will affect petition for your children, it will affect petition for everybody, because Adam Walsh Act specifically was enacted to protect children. So that is the way it works. The next question: what standard is used to adjudicate Adam Walsh Act cases when deciding if the petitioner is a risk? Is it on the balance, beyond the reasonable doubt, and all of that? Well, if we are talking about standard, that means we are talking about the waiver. Because as far as Adam Walsh Act is concerned, there is no issue of standard. It's either was this person convicted or was this person not convicted. If you are tried and you are discharged and acquitted, Adam Walsh Act will not affect you. But if you are convicted, of course, we know that in criminal cases, conviction is the standard of conviction is beyond all reasonable doubt. So that is the standard. So if you now go to talk about waiver, yes, immigration uses that same standard beyond all reasonable doubt. And again, this is another area where we run into trouble when it comes to applying for a waiver. Because the way immigration interprets it is that they want a medical provider to give you a report that will say that for sure they are certain beyond all reasonable doubt that you will not be a danger to the community. There is no medical provider that will do that. There is no medical provider that will do that and not lose their license. So the standard is almost impossible to meet. So that is the way immigration consider it, because we are talking about criminal issue here. Immigration issues generally, the standard of proof in some immigration cases is preponderance of the evidence. In other words, you put up the lady justice, folded lady justice with a scale. So you look at where the scale tilts. So is it in favor or is it against? But when it comes to Adam Walsh Act, because it is something that has to do with a crime, and standard of conviction in a criminal case is beyond reasonable doubt. So when it comes to Adam Walsh Act and you are applying for a waiver, immigration is going to apply that standard beyond all reasonable doubt. But I want it to be clear, this is not about Adam Walsh Act. This is about waiver. And like I said, this is one of the reasons why 99% of waiver cases when it comes to Adam Walsh Act are denied, because the standard is almost impossible to meet. There is no healthcare provider who will put his or her license at stake by the right. That medical provider is going to be in trouble. He or she is going to lose his license. Excuse me. So that is why it's almost impossible for any medical provider to give you that kind of certification. That is almost impossible. The next question. I'm a registered sex offender and I have a spouse. I have a spouse visa pending. I've been denied twice. My wife has a chance at an H1 visa. But we are concerned about the risk of being denied re-entry. She has not yet been granted a parole document. It has been pending for over a year. I don't think this question is complete, because I don't understand. I mean, how is talking about H1B visa and talking about parole. Parole is not associated with H1B, so I don't understand the question. Well, if the writer of this question is listening, I want you to please clarify it, because there are multiple issues here that I don't understand. I mean, if you are applying for H1B, H1B is a non-immigrant visa, and H1B is not associated with parole. So if we are talking about parole, we are talking about immigrant petition. So I don't see how. So is this parole based on the petition that was filed? But it says the petition has already been denied. Okay, he has I'm a registered sex offender and have a spouse visa pending. So is this visa together with I-485? Because if you are there are issues that are muddled up here. In a spouse petition where the spouse is abroad, there is no issue of parole. But what I want to say is, if your spouse is abroad and your spouse is eligible for H-1B visa, that is separate. That has nothing to do with you, except you are the employer. If you are the employer petitioning, yes, it may still come back when it gets to the adjustment stage. But other than that, I don't see any nexus between H-1B and your petition, because H-1B is employment-based petition and it's also a non-immigrant petition. It's not an immigrant petition. But if your spouse is abroad, then it means that the I-130 has to be approved first, and that has nothing to do with the H-1B. So I don't know if you can clarify the question, that will help. In the meantime, let me go to the next question. Is the processing time longer for cases under the Walsh Act? Well, not that I'm aware of. I think the same processing time for all I-130 are the same, because in the processing time log, they don't separately classify the Walsh Act. The way they classify it is U.S. citizen filing for immediate family. That means spouse, parent, or minor children. U.S. citizen filing for unmarried child over 21. U.S. citizen filing for married child over 21. Permanent resident filing for spouse or unmarried child under 21. Permanent resident filing for unmarried child over 21. U.S. citizen, adult U.S. citizen petitioning for siblings. Those are the way they classify it. They don't classify whether a case is Adam Walsh Act or not Adam Walsh Act. They are not classified like that. Yeah, even if it is referred for review, they will still not classify it separately under the processing time log. The next question. What is the BIA position on USCIS delayed adjudication of Adam Walsh Act cases? I don't think BIA is the one processing appeal on Adam Walsh Act. I think it is the Administrative Appeal Office. It is the AAO that processes appeal on Adam Walsh Act, not BIA. No, at least from the case laws that I know of, they are issued by AAO, not BIA. The next question. My Adam Walsh Act case has been denied. What can I do? Well, like I said, if you are convicted of Adam Walsh Act, then you are out of luck. There is really nothing you can do. That is the law. You cannot petition for your spouse. It's sad, but that is the law. There is really nothing you can do. But if you believe that your conviction was not Adam Walsh Act based, that immigration was wrong in classifying you as Adam Walsh Act offender, then you can file an appeal. There's provision for appeal. But if you know that you are truly convicted of Adam Walsh Act offense, then there's really nothing you can do. You are out of luck. Maybe I don't know, maybe you marry somebody else who will not require you to file a petition for him or her. So that's the only thing I can think of. Okay, the next question. Will an Adam Walsh Act offense affect a fiancé visa? Oh yes. It will affect a fiancé visa. It's the same thing. I mean, fiancé visa is still a family-based petition. So it will affect a fiancé visa. There is no room for different. There is no room for separation. It will affect a fiancé visa. Okay. While waiting for more questions, let me quickly go over. That seems to be the last question that I have. Okay. So while waiting for that, let me quickly go over this for the benefit of those who join us late. The Adam Walsh Act offenses. 1. An offense involving kidnapping unless committed by a parent or guardian. 2. An offense involving false imprisonment unless committed by a parent or guardian. 3. Solicitation to engage in sexual conduct. 4. Use in sexual performance. 5. Video voyeurism. And I explained that before. What that means is that if you record somebody with your phone or any device without that person's knowledge, if you record someone in nude position, I know that before this law was passed, there was a case of somebody who was in an hotel and somebody planted a recording device in the hotel room, and this person didn't know, was in the hotel doing her thing, only to find out later when this video was posted online. Everyone who participated in sharing this video, they are guilty. They may be convicted of video voyeurism. And that is why I'm explaining it. So if your child is in school and somebody send him or her a video on WhatsApp, or even as an adult, if you receive a video or on WhatsApp of people who are nude and who did not know that those videos were recorded, you can be arrested and convicted of video voyeurism, and then you become somebody who is convicted of an offense under Adam Walsh Act. That is why it is very, very important to pay attention. The next offense is possession, production, or distribution of child pornography. The next offense, criminal sexual conduct involving a minor or the use of internet to facilitate or attempt this conduct. And the last but not the least, any conduct that by its nature is a sex offense against a minor. Any conduct that by its nature is a sex offense against a minor. Those are the offenses under Adam Walsh Act. So let me see. I think I have one or two questions. I will answer them before we close. What will happen if I went back to court to fight and get the conviction overturned? Is that possible? Oh yes, it is possible. It is possible because, if you have reasons to fight the conviction, because like I said, my position is that this law, Adam Walsh Act, only affects people who are convicted. So if you are able to get your conviction overturned, then I don't think you will be convicted of Adam Walsh Act. So you may be able to solve the problem if you are able to have a collateral attack on that conviction and have the conviction overturned. I believe that you'll be able to resolve the problem. Now, the last question here, sir, can you answer my question? Thank you, sir. I've learned so much about that. Act law. Okay, let's go to that question. What is that question again? Okay, can you please explain what 4 years and 1 day rule mean? Well, again, I don't understand that question. So if you can expatiate on that, that's a question that is not clear. I have no idea what you are talking about. 4 years and 1 day rule. I don't understand what you mean. The next one, is that the explanation in the next one? I think so. Okay. I got my green card October 2018. Travel outside the USA from November 2018 to September 2019. So November 2018 to September 2019, that's how many months? That's like 9 months. September is 9. That's like 10 months. Okay. Since then, I've been in the USA. When can I file for citizenship? Again, this question is not complete. This question is not complete because when we are talking about citizenship, there are different categories. Immigration law is not a one-cap-fits-all. And I believe that we have videos on citizenship, eligibility for citizenship. You might want to go back and review it. But let me give you an answer to the best of my knowledge, to the best of my understanding of your question. Because number one, this question does not explain the category of your eligibility. It doesn't explain whether you are married to a U.S. citizen. It doesn't explain whether you have a child or spouse or parent who is in active military duty. It doesn't be a permanent resident for 5 years. So there is a lot of things that I don't know. So my answer is going to be based on a lot of assumptions. So I hope you will understand. But again, if I didn't answer the question satisfactorily, you can go back to the video we have on citizenship. And I know that we have multiple questions and multiple videos on citizenship. I think there is one specifically that says general citizenship questions. So you can go back to review it. But let me say this. If you obtain your green card as the spouse of a U.S. citizen, you are required to be a permanent resident for 3 years. And because you have been out of the country for 10 months up to September, so you start counting your 3 years from September 2019 when you came back. So that will be September 2020, September 2021, September 2022. So that means you are already eligible for citizenship. On the other hand, if your eligibility category is based on 5 years, now when you left the US in November 2018 and returned on September 2019, whatever number of months or years that you accrue before that time is cancelled. So your 5 years started from September 2019 when you re-entered the US. So if you count from September 2019, that will be 2020, 21, 22, 23, 24. So that will be September 2024. But of course, you can apply 3 months earlier. So that will be August, July, that will be June of 2024. So I hope I've been able to answer your question. So that is the best answer I can give based on the available facts that you provided. So in the absence of any other question relating to Adam Walsh Act, I want to thank you again for joining our podcast. Remember, we do this free of charge. We do not charge for it, and our questions are limitless. For as long as you ask questions relating to the topic we are discussing, we don't limit the kind of question that you can ask, and we answer every question to the best of our ability. So remember to invite your family members, remember to invite your friends to join us next week, every Wednesday, 12 p.m. Central Standard Time. That is currently 1 p.m. Eastern Time. That is currently 10 a.m. Pacific Time. And that is currently 6 p.m. Nigerian Time. So remember to join us, remember to invite family, friends, and remember to also follow us on social media. Let me tell you this, apart from this YouTube channel or Facebook channel, we also do have a daily reel where we provide significant and valuable information on daily basis. Every single day, we have this short message that is very, very informative. So if you join us on what platform now? On Instagram, on TikTok, YouTube, Facebook, we provide all this information on daily basis. So remember to invite your family and friends, And the only thing you can show to show appreciation is not to keep this information to yourself. Let others too benefit. I mean, of what value is it if you are the only one benefiting from this? Let others benefit as well, especially since we are doing it free of charge and we are not charging you. We hope to see you again next week. We thank God for today. Join us next week. See you next week. Here is Dr. Olu Asekun again. Thank you. God bless.